Marriage-based immigration and citizenship policies are undergoing significant updates, with a focus on increased scrutiny for all applicants. Officials state that these changes aim to enhance the integrity of the system through more detailed verification procedures. Applicants can now expect expanded background checks and additional documentation requirements during the green card review process. Being prepared for more in-depth interviews is critical, as a legal marriage does not automatically guarantee residency. Always rely on official government guidance and ensure your documentation is complete and accurate for your specific case. Marriage remains a legal pathway, but being prepared for longer processing times and detailed reviews is more important than ever. Stay informed by following official updates as policy implementation continues to evolve across the country. Marriage-based immigration has fundamentally changed in 2026. What was once a high-priority path is now facing unprecedented scrutiny. New policy defines adjustment of status as discretionary relief. This gives officers broader authority to deny applications even when basic legal requirements are met. Mandatory in-person interviews are back. Expect Stokes interviews, where couples are questioned separately on every detail of their lives together. Vetting now includes 10 years of social media history. Any content deemed contrary to U.S. interests can be grounds for immediate denial. USCIS has adopted a zero-tolerance policy for errors. Missing a single form or medical exam can now lead to immediate rejection without a request for evidence. The administration's stance is clear. Immigration is a privilege, not a right. For families, staying informed and perfectly documented is now a necessity. We will continue to track these evolving rules. Stay tuned for further updates on these critical policy shifts. Welcome back. In part 3 of our series, we look at the rising financial hurdles for married couples, from deep dive asset reviews to zero-tolerance filing rules. The updated Form I-485 now requires an exhaustive list of household assets and debts. Every bank account, investment, and loan is now under the microscope. Filing standards have reached a zero-tolerance level. Missing a medical exam in your initial packet can lead to immediate rejection rather than a request for evidence. The administration is also collaborating with financial institutions to verify the legitimacy of joint bank accounts shared by married couples. With separate payments required for each form and fees retained even after administrative rejections, the financial cost of a single error has never been higher. In this new environment, financial precision is mandatory. Couples must ensure every decimal point and document is accounted for from day one. In our next segment, we'll examine how these changes are impacting consular processing and military families abroad. Stay with us. Welcome to Part 4. Today, we focus on the global reach of these policies, specifically the growing backlogs at U.S. consulates and the impact on families abroad. By early 2026, the average wait time for family petitions reached 13 months. Consular processing has slowed significantly, especially in regions with expanded visa pauses. Surprisingly, even military families aren't immune. Reports in 2026 highlight cases of military spouses facing deportation while their partners are deployed overseas. The administration has also rescinded guidance recognizing informal marriages, impacting refugees and LGBTQ+ couples who cannot lawfully marry in their home countries. Expanded vetting in countries like Pakistan, Nigeria, and Kenya has further elongated wait times, leaving thousands of families in a state of indefinite uncertainty. The message from the administration is consistent. Every application, regardless of the sponsor's status, will undergo extreme vetting, often resulting in prolonged separation. In our final segment, we will look at how this vetting follows residents all the way to their citizenship applications. Stay tuned. In the final part of our series, we look at the path to citizenship. For many residents, the extreme vetting process doesn't end with a green card. USCIS has implemented a rigorous process to re-verify personal histories during naturalization. Officers are now looking for any inconsistency, no matter how small. A 2025 executive order has expanded the interpretation of the good moral character clause. Even minor civil infractions can now be grounds for a citizenship denial. The original marriage-based green card application is also being reevaluated. Perceived inconsistencies from years ago can now resurface during the final interview. The administration emphasizes that citizenship is a privilege, not a right. This shift has created a chilling effect, leaving many families in a state of uncertainty. From initial filing to final naturalization, the era of extreme vetting is here. For families navigating this system, staying informed and prepared is more critical than ever. Thank you for following our special report on marriage and immigration. For more updates on U.S. policy, stay tuned to our channel. In part 6 of our series, we dive into the specific triggers that can lead to a home visit or denied status, the USCIS red flags. One major red flag is a marriage occurring shortly after arrival in the U.S., or filing for a green card immediately after entering on a tourist visa. Large age gaps between spouses are now automatic triggers for higher scrutiny, requiring more extensive proof of a shared life and genuine bond. Expect unannounced site visits. Officers may conduct bed checks to verify that couples are indeed living together as stated in their application. To counter these triggers, couples must build a robust, bona fide marriage file, including joint finances, shared leases, and documented family history. Knowing these triggers allows couples to prepare more effectively. In this era of high scrutiny, transparency and solid evidence are your best defense. Thank you for following this deep dive into U.S. immigration policy. Continue to follow official updates as we track these evolving rules. In Part 7, we examine how the shift in marriage recognition is impacting some of the most vulnerable groups: refugees, asylees, and LGBTQ+ couples. In June 2025, the administration rescinded guidance that recognized informal marriages for those who could not lawfully marry in their home countries. This decision has effectively ended the ability for many refugee families to reunite, as their traditional or informal unions are no longer recognized for immigration purposes. LGBTQ+ couples from countries where marriage is illegal face similar hurdles, often finding themselves without a legal pathway to prove their committed relationship. Advocacy groups report a growing chilling effect, as mixed-status families fear that their non-traditional unions could now lead to separation or deportation. While the administration cites security, critics argue these rules target those with the fewest resources to fight back. Documentation and legal aid remain vital. Thank you for following our special report. We will continue to cover the human impact of these evolving immigration policies. Stay tuned. In Part 8, we examine the intense legal tug-of-war. Despite mass enforcement, recent court rulings are providing critical protections for many families. A landmark 6-3 Supreme Court ruling in June 2026 struck down the administration's attempt to end birthright citizenship, affirming the 14th Amendment's reach. While programs like parole in place were dismantled, a federal judge recently blocked the termination of family reunification parole, providing a temporary shield. Advocacy groups are actively litigating against increased fees and administrative barriers, ensuring that the voice of mixed-status families is heard in court. Experts advise that precise documentation and specialized legal counsel are now the most effective tools to navigate these discretionary review procedures. The legal landscape remains fragmented. For every executive shift, a judicial challenge often follows, making professional guidance indispensable for couples. Stay informed as we continue to track these high-stakes cases. Thank you for following our special series on marriage and immigration. In Part 9, we look at the psychological toll of extreme vetting, the chilling effect that is driving thousands of families to make the difficult choice of self-deportation. Advocacy groups have seen an explosion in membership. American Families United now represents over 1.4 million people seeking support amidst the policy shifts. Fearing indefinite detention and family separation, some mixed-status families are choosing to self-deport to their home countries rather than face the uncertainty of the vetting system. The constant stress of potential enforcement action is creating a climate of fear, affecting the daily lives and mental health of millions of U.S. citizens and their spouses. Local organizations are stepping up, providing legal clinics and mental health resources to help families cope with the trauma of living in a state of indefinite uncertainty. The era of extreme vetting is leaving a lasting mark on the fabric of American communities. For many, the American dream is being replaced by a struggle for stability. We will continue to report on the evolving landscape of U.S. immigration. Thank you for following our special series. Stay tuned for more updates. In Part 11, we address the administration's maximalist deportation strategy, which has seen over 500,000 individuals deported since January 2025. ICE reports indicate that enforcement actions are now targeting mixed-status households with unprecedented frequency, prioritizing mass removal over family unity. A central pillar of this strategy is the potential invocation of the 1798 Alien Enemies Act, a move that would grant the executive branch vast removal powers. Advocacy groups are already preparing legal challenges, arguing that modern migration does not constitute an invasion as defined by the 18th century statute. The controversy has reached a peak following reports of U.S. citizen children being deported alongside their parents, sparking national protests. As the administration pushes for stricter compliance, the legal definition of executive power remains the front line of this policy battle. We will continue to follow these high-stakes developments. Stay informed as we track the future of immigration in America. In Part 12, we look at the financial stability of mixed-status households facing new administrative hurdles that threaten their economic security. The administration has eliminated the 30-day processing rule for work permits, leading to significant delays and job insecurity for non-citizen spouses. New USCIS fee structures have substantially increased the cost of filing, placing an immense burden on middle and low-income families seeking legal status. Employers are also feeling the impact, as valued employees lose their work authorization due to administrative backlogs, disrupting businesses across the country. Coalitions like Democracy Forward are challenging these economic barriers in court, arguing that they destabilize families and the broader American economy. Beyond individual cases, the economic health of mixed-status families is becoming a critical point of debate in the national conversation on immigration reform. Thank you for continuing to follow our special series. We will bring you more updates as the economic landscape of immigration evolves. In Part 13, we address the most vulnerable members of mixed-status households, the millions of U.S. citizen children whose lives are being upended by enforcement actions. Legal controversy erupted in early 2025 following reports of U.S. citizen children being deported alongside their parents, sparking a debate over the rights of natural-born citizens. While the DHS claimed parents made the determination to take their children, attorneys reported that many families were denied legal counsel before being forced onto planes. The constant fear of separation is causing deep developmental trauma for children as they navigate an environment where their family stability is no longer guaranteed. Advocacy groups are now filing specialized lawsuits to protect the rights of citizen children, arguing that their interests must be prioritized in all immigration proceedings. The treatment of citizen children remains a central constitutional challenge. As the courts weigh in, the human cost of these policies continues to grow. Thank you for staying with us as we uncover every layer of this complex policy shift. Stay informed for the next part of our special report. In Part 14, we examine a pivotal proposal from mid-2026 that is forcing thousands of families into what advocacy groups call an impossible choice. The administration has proposed a rule requiring nearly all non-citizen spouses who entered without inspection to return to their home countries to apply for visas. Previously, programs allowed many to adjust their status without leaving. Now, exceptions are limited only to extraordinary circumstances, often leading to years of separation. The risk is significant. Once a spouse leaves the U.S., there is no guarantee they will be allowed to return, even with a pending family petition. Advocacy groups like American Families United argue that this rule effectively forces families to choose between permanent separation or leaving the U.S. forever. As the public comment period ends, the fate of hundreds of thousands of households remains in the hands of federal regulators. The impact on family unity is profound. Thank you for following our deep dive. We will continue to monitor the implementation of this controversial rule. Stay tuned for Part 15. In the final chapter of our guide, we provide a practical checklist. Building a bona fide marriage file is now the most critical step for every applicant. Start with your finances. Joint bank accounts with regular activity, shared credit cards, and commingled tax returns are the gold standard of evidence. Document your shared home. A joint residential lease, property deeds, and utility bills showing both names provide concrete proof of a shared life. Don't forget the personal touch. Family photos spanning years, travel itineraries, and affidavits from friends and family help humanize your application. Conduct a self-audit of your social media. With a 10-year review now mandatory, ensure your public digital footprint is consistent with your marital history. Precision and organization are your best defense. A complete, well-indexed file reduces the risk of administrative rejections and detailed interrogations. This concludes our special series on marriage and immigration. Stay informed, stay prepared, and follow our channel for more policy deep dives. Welcome back. In Part 17, we turn to the experts. Navigating the 2026 landscape requires more than just filling out forms. It requires a strategic defense. As of May 2026, USCIS requires lawyers to be physically present at interviews. Your attorney serves to flag procedural errors and prevent aggressive overreach in real time. A critical step is risk screening. If you have a prior removal order or criminal record, an attorney can determine if an interview is safe or if it could trigger an ICE arrest. Experts now emphasize front-loading your application. Submitting robust evidence of a genuine bond from day one is no longer optional. It is a survival tactic. Timing is also key. Filing for a green card too soon after entering on a tourist visa can lead to fraud charges. Lawyers suggest waiting at least 90 days before filing. In this era of enforcement, legal counsel is a necessity. The cost of a mistake, like a denial or deportation, far outweighs the cost of professional guidance. Stay prepared, stay informed, and follow our channel for more critical policy updates as we continue our series on U.S. immigration. Welcome back. In Part 17, we turn to the experts. Navigating the 2026 landscape requires more than just filling out forms. It requires a strategic defense. As of May 2026, USCIS requires lawyers to be physically present at interviews. Your attorney serves to flag procedural errors and prevent aggressive overreach in real time. A critical step is risk screening. If you have a prior removal order or criminal record, an attorney can determine if an interview is safe or if it could trigger an ICE arrest. Experts now emphasize front-loading your application. Submitting robust evidence of a genuine bond from day one is no longer optional. It is a survival tactic. Timing is also key. Filing for a green card too soon after entering on a tourist visa can lead to fraud charges. Lawyers suggest waiting at least 90 days before filing. In this era of enforcement, legal counsel is a necessity. The cost of a mistake, like a denial or deportation, far outweighs the cost of professional guidance. Stay prepared, stay informed, and follow our channel for more critical policy updates as we continue our series on U.S. immigration. In Part 18, we look behind the scenes at the legislative engine driving these changes, the Secure America Act and its massive funding for enforcement. The Act has allocated approximately $70 billion toward immigration enforcement, with nearly $39 billion specifically for ICE operations. This has shifted critical resources away from processing green cards and toward mass enforcement, resulting in a system focused on removal rather than benefits. USCIS has established a new LPR operations unit dedicated exclusively to deep dive vetting for fraud and national security concerns in every green card case. This technocratic wall includes expanded digital surveillance and extensive social media screening, creating a more complex hurdle for every applicant. The shift in funding represents a fundamental change in America's immigration paradigm. The focus is no longer on welcome, but on strict legal compliance. Thank you for following our investigative series. We will continue to track the long-term impact of these budget shifts. Stay tuned for Part 19. Welcome back. In Part 19, we examine the fundamental restructuring of the federal agencies that manage the American immigration system. A key development is the Trump versus Slaughter ruling, which expanded the president's authority to fire agency officials, clearing the way for a major leadership shift. This has enabled the installation of loyalists across the bureaucracy, ensuring that America First directives are implemented with minimal internal resistance. USCIS itself is being restructured, moving resources from its traditional service-oriented model toward a heavy focus on fraud detection and enforcement. These changes have sparked a debate over agency culture and the long-term impact on the neutral adjudication of immigration benefits. The overhaul marks a new era of administrative control, where the executive's policy vision is more directly felt at every level of the immigration process. Thank you for following our investigative report. We will continue to track these internal shifts. Stay tuned for our next update. In our final chapter, we bring together the pieces of a complex puzzle, the complete transformation of marriage-based immigration in the United States. From mandatory interviews to 10-year social media audits, the threshold for entry has shifted from a presumption of trust to a mandate of intense scrutiny. Financial hurdles and administrative rejections have added a layer of complexity that demands absolute precision from every applicant and sponsor. As we look forward, the legal battles in the Supreme Court and the advocacy of families will continue to define what family reunification looks like in America. The most powerful tool for any family is information. Staying prepared and seeking legal guidance remains the best path through this evolving system. This concludes our 20-part deep dive. We hope this series has provided clarity and support for those navigating the current immigration landscape. Thank you for following Global Insight News. For all future updates on U.S. policy, subscribe and stay tuned to our channel. Goodbye. In Part 21, we address a critical technical hurdle for those entering on temporary visas, the legal concept of preconceived intent. Entering the U.S. on a tourist visa with the hidden plan to marry and stay is considered visa fraud. In 2026, officers are trained to spot this from day one. While not a hard law, the 90-day rule is a vital guideline. Filing for a green card within 3 months of arrival can trigger an automatic presumption of fraud. A finding of preconceived intent can lead to a notice of intent to deny, effectively barring an applicant from permanent residency and risking deportation. Applicants must be prepared to prove that their decision to marry and stay was made after entry, documenting how their life circumstances changed since arrival. In this enforcement-heavy era, timing is a legal strategy. Consult with an expert before making any life-changing decisions shortly after entering the country. Stay tuned for the final chapters of our immigration deep dive. We will continue to cover the technical details that matter most to your family's future.